Well, good evening and welcome to the program. This is the Limelight, and my name is Prince Apollo. Now, this evening we do a sneak peek into the newly appointed judges and justices. And to do exactly that, I've been joined on the show by Paul Mukiibi. And Paul Mukiibi is the founding partner at Mukiibi and Cheyune Advocates. Paul Mukiibi, let's go straight to the impact of these appointments, especially in line with the efforts to deal with the huge case backlog in courts of law. What is your opinion? Can we now expect expeditious delivery of justice?
Thank you so much. Viewers and listeners of SALT TV, I greet you. Good evening, everyone. And I thank SALT TV management for hosting me on this very important discussion. Once again, allow me just to reinforce saying I'm Paul Mukiibi, founding partner of Mukiibi and Cheyune Advocates and a practicing advocate for now 17 years standing. I'm glad to also join you to welcome the new appointments on the bench. As has been rightly reported, we had a number of about 32. However, the number may sound high to the public, but in terms of justice dispensation and case backlog in the country, it is not even a 55% of what we need.
Sure.
Yeah, it is not. I might say, for instance, High Court, 21 judges were appointed. But if you look at the overall statistics of the Judiciary performance report, the last financial year 2023, 2024, the Judiciary had pending cases totaling to 161,838. It had cases we classify as backlog. Backlog cases in the judicial system are the cases that have been in the system for 2 years and above, not concluded. Those ones are 42,588 cases. When you add up, that makes it a total of 26.32%. Now, most of these cases are being tried in High Court. The appointment that has been made in High Court is of 21 judges. Out of the 21 judges, there are those who are going to replace judges retiring. We have judges retiring this year.
Yep.
The number may be about 7. So practically, the new appointments may be about only 14. And given the backlog, I can give an example. Luwero High Court Circuit alone has 1 judge, but the cases there are more than 4,000. Meaning that circuit alone needs about 4 judges. Go to other circuits, talk about, for instance, Masaka has 2 judges. One is on study leave. There is only 1. The case backlog is also big. So, as we are excited about the addition of the number, in terms of impact, it may not be very much. So we shouldn't excite the public so much, though we are appreciative that the number has somehow improved.
Is it only about the number of judges who are appointed, or the understaffing? Is it only about judges, or there is there are other factors possibly that cause this case backlog in courts?
The factors are several. Even if we are to add the numbers and have them many, some judges are naturally weak. They are non-performers. Now look at today, the promotion that have been made to Court of Appeal. 8 justices have been promoted from High Court to Court of Appeal. But can we get a track record of their performance in High Court? So as advocates, we are surprised. Some non-performers have been promoted. And they already have backlog and cleared. They are going to Court of Appeal, which is also more busy, again, to create more what? Backlog. So laziness is there. 2, this tendency of seeing somebody 1 year to retire, add him another 5 years to Court of Appeal, I don't think is a good factor. We should look at performance, previous performance. And also, we are also saddened that the performing judges we know of record, like Justice Mubiro in High Court, Justice Gidudu, are nowhere. And some are more senior.
In these appointments?
They are nowhere. Some of them, their caliber is Supreme Court, but they're in High Court. So the factors that are causing case backlogs in Uganda are quite several. It cannot be the number. Even if you appoint 100, but they are non-performers, the problem will still be there. Judges are always in conferences. Some don't attend court. They don't even communicate. There are those who are good, but majority are just there around. So the issue is not only the number. The issue is that what is the track record of these appointments? What can you tell? This one has this record and it deserves to serve as a high court what? Judge. Those factors we don't know. The public doesn't know. The appointments, the process is done in closed doors. There is no transparency and openness to public scrutiny like other jurisdictions. If you're going to be appointed a judge, the interviews are open. The public will give that this man has been in this organization and has even crushed it. He's a non-performer. You get those views, but all these are not known. The vetting in parliament is also done in confidence. This does not give us a yardstick to get good performance.
When you talk about the non-performance of judicial officers, are you not talking about the role of the Justice Service Commission, the Judicial Service Commission, Judicial Service Commission? What are they doing?
That is still another angle to look into. How much power does the Judicial Service Commission have over its judges, its supervisors? By law, it has the powers, but practically, what is it doing? Because some judges can spend a year without delivering a single judgment. Others can spend a year delivering less than 10 judgments. Then, when promotions come, they are the first to be promoted. Those who have cleared backlogs from one place to another are left. There is a very serious problem with the JSC. Is it doing its work? Is it being interfered by external factors? That is something also we can discuss. But overall, we don't feel its power.
It's power and
we don't feel it.
What other factors could be limitations in dispensation of justice, actually timely dispensation of justice, in order to eliminate this case backlog? What could be the other limitations?
One is the nature of our adversarial system is also laborious. It has so many processes to when you file a case from in to out is quite a long period of time because of the colonial processes we've looked at. We have recommended certain procedures are no longer necessary.
Like what?
Now, for instance, you file a matter, you have to wait for court to issue summons. That can also take time if the judicial officer is weak. After summons have been issued, you go and serve them. The other party is given 15 days, for instance, for an ordinary suit to file a what? A defense. Sometimes it doesn't even file on time. Brings applications. All that is adding on the time the matter. Then when it comes to trial, witnesses come, cross-examine, examining chief, re-examining. The processes are too many to have a case move out. And this is one judge who has a day about 10 cases. So if one case is to proceed, even if your witnesses are all there, the judge is forced to hear one or two because others are also waiting to be attended to. That is one. Two, also writing incompetent judgments. This is a growing problem. We have judges fighting their personal battles, writing very, very weird decisions. All these are causing appeals. And that is overworking the appellate what?
Appellate court.
And what annoys us more, those are the priorities for promotion. You see, it is very, 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 very disappointing.
While you speak about incompetent judgments, what you call incompetent judgments, you're speaking about the independence and impartiality in dispensation of justice.
No, the incompetent judgments, I mean, judgment you see that is not based on law and reason. It is, on the face of it, it is wrong. Definitely, just know people have been in your court for 10 years, but the decision you've given them is sending them to start another process of appeal. Now that means if they've been in your court for 10 years, they are likely to go to the other court and spend another 10 years. But if you give a decision that is based on the law, reason, even if I've lost, I just tell my client, we've lost genuinely. You don't need to what? to appeal. But their decisions yourself you reject from the moment you see it. And those decisions are many today.
When you look at the appointments that have been recently made,
Yes.
the newly appointed judges and justices,
Yes.
do you see an element of impartiality and independence in dispensation of justice?
To me, I'm actually one of the proponents that the entire process of appointment is the starting problem we have, because we don't get to know how many applied. I can give an example in Kenya. When an advert is placed, people apply who are qualified. They published a list of those who applied and their qualifications. By the time shortlist is done, people are contented. So and so deserved to be shortlisted.
Yeah.
In Uganda, it is the opposite. You don't know who has applied. You don't know what qualifications the person has. Selection, where they start shortlisting, is their personal business. Those who don't go through are never given a reason why they were never shortlisted. Those who are shortlisted don't have a reason why they beat their colleagues. Now that brings room for corruption, room for favoritism, and room for selecting what you want, not who qualifies. The interviews are done in closed doors. The public never gets to know that Apple passed this question. Apple really deserved for appointment. No one will know. You just see a list being published later on. These are the people that have been
appointed.
Then you ask yourself, what criterion? There are judicial officers who have worked from lower level and have upgraded. There are advocates who have practiced hands-on. They have all tried in vain, but they never get to know why. Then when you see some appointees even asking, where is this one coming from? You have no idea. So that is the starting point where we do it wrong. And we are saying this system must change. It must change if you are to get competent judicial officers, hardworking people. That will help us reduce backlog. They will be hardworking because they know they went through meritocracy and they need to defend that merit. Secondly, they will make decisions based on law and reason, and lawyers will respect. If you lose a case, just tell a client, don't bother appealing. But today, almost appeal is automatic because most of the decisions are wrong.
Where now do we start from if we are to address this issue? Do we start from Parliament amending the law? Where do we start from?
Yes. First of all, the point you've raised is very critical. The existing laws are themselves a bar. We have a Judicial Service Act.
Yeah.
There's that section 16, which is preventing these issues of transparency and openness. In fact, there was a case in the Constitutional Court, that is Simon Njarakagwa and the current President Isaac Semakade against the Attorney General, challenging the vetting process and also the procedure of appointment. Funny enough, the cases before, the people who went through the same process and they benefited from it. So they legalized this and they saved it. And we are saying maybe some of these cases should be tested in the regional court, like the East African Court of Justice, whereby the beneficiaries are not the one to again determine what they benefited from. And I think that will save us. Otherwise, the existing status quo is very worrying. It is making legal practice just something for formality. We are no longer enjoying it. The buzz, you go to a judge and you are worried that this one cannot give me a right decision.
Well, if we are going to address the issue of the case backlog, with the, like you said, low staffing, I mean, low staff levels in all judicial offices, even with a few judges and justices in these courts, what can be done? Can we have a system to improve the efficiency, to do away with the laziness you've talked about? How can that be possible?
Yes. We have always challenged the chief registrar, the principal judge in backbench meetings, that what are your key performance indicators? What are your performance grading system? How do you know Judge X is doing the right thing? how do you know Judge X is doing the wrong thing? Where are those performance appraisals you do? And how do they guide decisions you make? That is lacking. We need to have a clear performance appraisal whereby we can know the performance
for judges.
And it is very easy to know because the stakeholders are many. Start from the bar, the lawyers themselves who appear before them. I will know corrupt judge. Very much, I will know that judge doesn't deliver decisions because he fears to surprise everybody. Sometimes has taken money from all.
That is where we've reached. You know that
but even the IGG reports are there, which have indicated that the judiciary is one of the most corrupt institutions. These are not news. The things have been happening. Others are naturally lazy. They go to work a day, he has only one file. And you have had the one file, but there's no substantive work done in it. It is not good. Then we also have a weakness of undermining merit performance. You can see some judges really do a lot, work a lot, clear a lot. Those judges retire at the same level. Now, what message are you sending to others who would want to work harder? That for you, that is not a consideration. Do it at your own. So we need to really value merit. There are judges who do work a lot, judges who make good decisions. We need to see them going through the system from one level to another. But when we see these ones who are making decisions, everybody is appealing. They are rising from one level to another. Then you also tell us you want your problem to stay. You don't want it to end.
In one of the appointments that were made recently is the elevation of the now former principal judge Flavian Zeija to the position of the Deputy Chief Justice, and the office remains vacant. Is that a concern? The office of the principal judge, is that a concern?
Well, right now it is not yet vacant because I understand the current DCJ, the substantive one, Justice Richard Taylor, his contract is running up to April, sometime in April. So he's still in office. The new appointee, Dr. Flavian, will be joining the other office sometime in
after
April.
Taylor retires.
Yes. So in between now and that time, we expect an appointment either in acting capacity, acting PJ, or because I don't see we have a problem, the JSC now is not constituted, the Judicial Service Commission, which we recommend to the president. So I don't think between now and April we may have an election. My thinking is they may appoint one in acting capacity. But right now, Flavian is still there until that time.
Finally, the 21 judges of the High Court were appointed in acting capacity. Is that also a concern?
Very much a concern. As a lawyer, I totally don't believe in that concept of acting capacity. And I've always talked about it undermines judicial independence, which is a core principle and a core safeguard of security of tenure of judges and their independence. We have had a scenario of Justice Mukiibi, who has not been given instrument of appointment because she has been in acting capacity. You see, when I'm acting and I have somebody telling me to do what he wants and is appointing authority, how will I remain independent? The Constitutional Court, in the case of Dr. Husinje Kawumba and Andrew Karamaja against AG, has ruled on that. It has said acting capacity is wrong. But the AG appealed to the Supreme Court, and even this decision was stayed. And we are just there, it is stayed, the practice is continuing. Why doesn't the judiciary prioritize some of these constitutional matters and resolve them?
So how do you respond to that? You as practitioners?
For us, we are now demanding, the Supreme Court to come up with a final decision. Because the Constitutional Court had cleared it. Then the other people appealed to the Supreme Court. And now the danger we have, when some of these serious constitutional matters go to Supreme Court, it is like barring them. It takes decades to make a decision. We need to prioritize, come up with a decision, pronounce whether the appeal makes sense or it does not, then we resolve the problem. So as advocates, we are demanding the Supreme Court to come up with a decision on that matter, so that the public, like we have been with the General Court Martial, we had also to demand to get that decision. Why should we demand? You are supposed to dispense justice. You are supposed to make decisions. Don't always be demanded to do so. That causes a problem and it causes a stampede, because the Constitutional Court has already interpreted. And also find the issue of staying constitutional court decisions not really right in our system. But it was started somehow and it is operating.
So we cannot celebrate these appointments because they may not be of...
Yeah, when they appoint you in acting capacity, that's what it means. They may either confirm it is like being on probation on another job. Your probation, maybe it is 6 months. You can even imagine in other organizations 6 months. But a judge 2 years acting capacity, and you think the judge will be independent in those 2 years? Never, because wants to be confirmed. So if I have a case concerning the appointing authority, how would I decide it when I'm on enacting capacity? If I annoy the appointing authority, will I be confirmed? So what is the independence? It is just something unheard of. Many jurisdictions have dealt away with it. Even the IBA standards don't really promote this issue of acting capacity.
Well, congratulations to those who were appointed and confirmed or approved by Parliament. We can now wait to be witnesses of your good work. And of course, justice delayed is justice denied. We must do away with this challenge of case backlog in courts. My name is Prince Apollo. Thank you so much for watching. Paul Mukiibi was and is my guest, the founding partner Mukiibi and Chaine Advocates. We'll catch up again next Friday in another edition of the Limelight. After here, we'll be going into Emisingi with Pastor Aloza Subjingo, and later we join Canaan Land in an power packed overnight. Hope to meet you there. Good evening, God bless you, and God bless Uganda.